In this video, we'll discuss and critically analyze part 10, which is the last part we have framed in relation to protection of life and personal liberty as provided under Article 21 of the Fundamental Rights. So, under different heads, we will critically analyze how the apex court or Supreme Court expanded and widened the very scope and ambit of Article 21, and in relation to that, we'll discuss the first one, that is relating to foreign travel and passport, and in that connection, we'll discuss certain important leading cases. So, in relation to foreign travel, we would like to discuss the very important leading case that we have not mentioned here, and that is Satwan Singh Sahani versus Dr. D. Ramanathan, and it was a case of 1967 where Supreme Court pronounced right to go abroad forms part of Article 21, and in relation to passport we will discuss the important leading case Maneka Gandhi versus Union of India in 1978, as it was pronounced by our Supreme Court that is, citizens' passport cannot be impounded for an indefinite period of time. The requirement of natural justice being implicit in Article 21, the Passports Act 1967 would be construed by the court as requiring hearing before taking prejudicial action. And now we'll go to the second facet that falls under part 10, is that relating to privacy, and in relation to that we'll discuss the important leading case Justice K.S. Puttuswamy retired versus Union of India, and it is a case of 2018 decided by Supreme Court. Also another important leading case relating to privacy P. Madhan versus Santa Kumari versus Santa Kumari 2015 by the Madras High Court. So also another important leading case relating to privacy is Payal Bhuvaneshwari versus Naga Panendra Rayal in 2008 by the Andhra Pradesh High Court, where it was why the Supreme Court and 9 judge bench of the Supreme Court held that right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21, and as a part of the freedoms guaranteed by Part 3 of the Constitution. Examining the constitutional validity of Aadhaar Act, the Supreme Court held that it is beneficial legislation aimed at empowering millions of people in country, and the project cannot be solved merely on apprehension. Section 33 of the Aadhaar Act was read down by clarifying that individual whose information is sought to be released shall be afforded opportunity of hearing. Section 33 clause 2, corporate and an individual body about the information, and it would be struck down if the very portion 57 of the Act which enabled a body, corporate and an individual to seek authentication was held unconstitutional. However, the Supreme Court held that the requirement of Aadhaar would not be compulsory for school admission of children as it is neither service or subsidy. A child has a fundamental right to education under Article 21A of the Constitution, and admission cannot be treated as a benefit as it was decided in this important leading case. Justice K.S. Puttaswamy versus Union of India in 2018, and it is also important in the connection as it is called as the Aadhaar case. And now we'll go to the second important case, that is relating to B. Madan versus Shanta Kumari, where it was held that Article 21 relates to protection of life and personal liberty, which enables the wife to live with human dignity. The medical test conducted to decide whether the marriage has not been consummated owing to the importance of the husband could not be against his privacy, therefore directing parties to undergo medical examination would not be improper, as it was held in this important leading case, B. Madan versus Santa Kumari in 2015. And now we'll go to another important leading case, and that is Payal Bhuvaneshwari versus Naga Phanendra Rayala versus, and it is a case of 2008 of Andhra Pradesh, as it was the decision, the act of recording conversation of his wife by the husband without her knowledge would amount to infringement of our right to privacy, as it was held in this important leading case relating to privacy. And now we'll go to the third facet that we have selected regarding protection of life and personal liberty, which is relating to telephone tapping. So, in that connection, we would like to discuss one important leading case, and that is People's Union for Civil Liberties versus Union of India in 1997. The Supreme Court pronounced telephone tapping would infringe Article 21 of the Constitution unless it is permitted under procedure established by law. The court issued guidelines for the exercise of the power of interception of telegrams under Section 5, Clause 2 of the Indian Telegraph Acts 1885. In this particular important leading case relating to telephone tapping, and that is People's Union for Civil Liberties versus Union of India. And now we'll discuss regarding another facet which also relates to protection of life and personal liberty as falling under Article 21, and that is relating to reputation. So, in that connection, we'll discuss most important leading case, and that is Kishore Smriti versus State of Uttar Pradesh 2013. So, in relation to that, we will discuss as it was pronounced that the reputation is an element of personal security and is protected by the Constitution equally with the right to enjoyment of life, liberty, and property as enshrined in Article 21 of the Constitution, as it was held in this particular important leading case, Kishore Srimit versus Union of India in 2013 by our Supreme Court, and so also in another important leading case, that is Om Prakash Chautala versus Kanwar won in 2014. The Supreme Court expressed that a good reputation is an element of personal security and it is protected by the Constitution equally with the right to enjoyment of life, liberty, and property under Article 21 of the Constitution, as it was also decided in this important leading case, Om Prakash Chautala versus Kanwardhan in 2014. And now we'll go to the very facet relating to sexual harassment. And in relation to sexual harassment, we would like to discuss the most important leading case, that is Vishakha versus State of Rajasthan. And in this very important leading case relating to sexual harassment, we would like to discuss the very decision of the Supreme Court relating to sexual harassment, and the Vishaka case is considered as the first ever such case relating to sexual harassment, which created an history in India by exactly dealing how it is a part of right to life and personal liberty, and in that connection the Supreme Court pronounced that sexual harassment in the workplace is a violation of Article 15 and 21 of the Constitution. The court gave detailed direction on the subject with guidelines are to be strictly observed by all employers, public or private, until suitable legislation is enacted on the subject, and that is sexual harassment. And besides that, we'll discuss another important leading case, and that is also relating to sexual harassment, and that is Medha Katwal Lily versus Union of India in 2013. The Supreme Court expressed that if there is any non compliance or non adherence to Visakha guidelines, which were issued by the Supreme Court in its 1997 judgment, it would be open to every person to approach the respective high courts as it was decided in this leading case, Meda Kotwal Lilly versus Union of India in 2013. And now we'll go to relating to another facet that is falling under right to life and personal liberty relating to sex workers. And in that connection also we would like to discuss another important leading case, and that is Buddhadeva Karmakar versus State of West Bengal in 2013. The Supreme Court expressed the conditions conducive for sex workers to live with dignity in accordance with the provisions of Article 21 of the Constitution should be understood in its correct perspective. As for example, they may be provided alternative source of employment for their rehabilitation to live life with dignity, as it was pronounced by the apex court in this very important leading case, Buddhadeva Karmakar versus State of West Bengal in 2013. And now we'll go to the important part that we have to discuss, which we have included under part 10 relating to protection of life and personal liberty, and that is scope of Article 21. And in that connection we'll discuss some important leading cases like Francis de Corralic versus Union Territory of Delhi in 1981, Solso Wolcatellis versus Bombay Municipal Corporation, a case of 1986, Solso Nandini Sundar versus State of Chhattisgarh, a case of 2011, Solso Muhammad Sukkar Ali versus State of Assam, a case of 2011, and Somnath versus State of Andhra Pradesh of 1997, and the last, that is G. Sundar Rajan versus Union of India in 2013. The very scope of Article 21 as it was interpreted by the apex court, and the very scope, the ambit, and the jurisdiction of Article 21, how it was widened and how expanded by our Supreme Court, that here we will critically analyze with this important leading cases. So, as we found from those judgments, as Article 21, if read literally, is a colorless article and would be satisfied the moment it is established by the state that there is a law which provides a procedure which has been followed by the imposed action, but the expression procedure established by law in Article 21 has been judicially considered as meaning a procedure which is reasonable, fair, and just. Read with Article 39A, it would further imply legal aid being made available to the indigent, accused, and a prisoner. The concept of fairness so evolved has been imported into Articles 22, Clause 3 also, so that a prison regulation which arbitrarily deprives a detainee of opportunity to interview his relatives or friends or a lawyer is invalid. So, right to life and right to personal liberty in India have been guaranteed by a constitutional provision which has received the widest possible interpretation under the canopy of Article 21 of the Constitution. So many rights have found shelter, growth, and nourishment. An intelligent citizen would like to be aware of the developments in this regard as they have evolved from these judicial decisions. Article 14 and 21 of the Constitution have been violated and they will continue to be violated by the appointment of tribal youth with very little education as SPOs engaged in counter-insurgency activities, as it was decided in this particular leading case, Nandini Sundar versus State of Chhattisgarh in 2011 by the Supreme Court. And in regards to another important leading case, Article 21 lays down that no person shall be deprived of life or personal liberty can be said according to procedure established by law. Life in Article 21 is not merely the physical act of breathing. So, Article 21 of the Constitution, which guarantees protection of life and personal liberty, can be said to be heart and soul of the fundamental rights as it was pronounced by our Supreme Court in this important leading case, Muhammad Sukar Ali versus State of Assam in 2011. So, also, safety, security, and life come within the ambit of Article 21 of the Constitution. No jettisoning is permissible, as also it was held in the important leading case G. Sundar Rajan versus Union of India in 2013 by our Supreme Court. So, almost we have discussed all the 10 different parts that we have framed in regard to Article 21, which deals with protection of life and personal liberty. And at present, we have finished all these 10 different parts in 10 different videos. And this is the last video, that is part 10, dealing with the very ambits relating to foreign travel, passport, privacy, sexual harassment, sex workers, telephone tapping, reputation. So also, lastly, the very scope of Article 21, how the very ambit and its jurisdiction as per the interpretation of the Supreme Court is so expanded and widened that at present it includes every facet of one's life, that is falling under protection of life and personal liberty as enshrined under Article 21 of the Constitution.